I was just too cheap to buy all colored ones, to be honest.
Hey, cheap is good. Cheap is always good.
All right, ladies and gentlemen, pursuant to my contract with you, we're going to be starting this seminar at 6 p.m. And we'll be done probably by 7, unless you have questions. I'm here all night, so whatever you want to do. There, please do. I assume that you're either interested in leaving a legacy for your children or your loved ones, your beneficiaries, or you want to see how you can save money on your account. If you came with the intent of trying to get answers to either one of those fields, you are in the right place. If you came here to find out how to become a dog walker, I cannot help you. So, a little bit about myself. This is not really about me, but just so you know who I am. I graduated from law school in 1989 from a place called Stanford University Law School. You may have heard of it. I'm originally from Northern California. My first job, I worked with a guy named Melvin Belli. You may have heard of him. Melvin Belli became famous by representing Jack Ruby, who killed Lee Harvey Oswald in front of millions of America. And yeah, Mr. Belli, why would you represent this guy? How do you win a case where somebody shot and killed somebody in front of millions of Americans and the entire world? Well, he did. That put him on the map. And then after that, he swore that he was never going to do a criminal case again. And so he got involved in personal injury law, which of course was far more lucrative because of course, Jack Ruby never paid him. He died in jail of a heart attack, I think. And so Mel Belli's wife said, look, Mel, what are you doing? You got your law license. Do something where you can support your family. So he did personal injury, and he was called the king of torts. What does that mean? Well, it's a tort. You might think, oh, that's a French pastry, right? No, a tort is a wrong against a person, as opposed to a crime, which is a wrong against society. So, you see these commercials on TV all the time. Have you been involved in an accident? Did a dog bite you? Were you shopping at Gelson's and did you fall down? We can help you. We'll get you money. And here's the interesting thing that I find. They always say, we will never charge you up front. We only charge you if we win your case. Hey, that's nothing exciting. That's what the law tells them to do. So they act like this is some great benefit that they're providing to the public, but in reality, as a personal injury attorney, you're not allowed to collect a fee up front. It's not legal. Anyhow, that's a little about me. I teach law. Contract law at a place called San Francisco Law School, which ironically, their campus happens to be in San Diego. And I was telling some other people that I originally taught at San Francisco Law School in San Francisco after I graduated from Stanford, but they had a campus in San Diego. They still do. So I got a call from the dean in San Francisco that said, hey, CJ, can you come teach contract law? I said, I don't live in San Francisco anymore. So that's no problem. We're in San Diego. So, okay. So I trucked down there, and right around the coronavirus started to happen, I was all excited to have my online class start, and it did. I was hoping for in-person, but no, coronavirus shut everything down, and I did my first online course in teaching contract law, which was interesting, but for me, I prefer to teach one-on-one. It's more interactive, and if people have questions, they can interrupt me at any time. And like tonight, there are really no rules, except there are some snacks on the back, water, some sweets. Please eat them, because I don't want to take them back. So that's really the only rule for tonight. If you have a burning question, I'll probably answer it, but if there's something that is just catching you on fire and you can't wait any longer, raise your hand, okay? We'll take care of it. Don't worry about it. All right, so estate planning. Let's talk a little bit about estate planning. There are kind of two sections to estate planning. One is the document preparation. And you can go to a lawyer, you can go to a paralegal, you can do it yourself. However, you want to make sure that it's done correctly. Now, if you go down to some lawyer in Beverly Hills or Century City or Encino next to my office, they're probably going to charge you about $2,000 to $2,500 for an estate plan. Now, here's the kicker.
More.
Or more.
More, yeah.
Now, here's what makes me cringe. You go into a law firm and you want an estate plan. Maybe you want a living trust, maybe you want an irrevocable trust, which we'll talk about in a moment, the differences. So what they do is they say, hey, how much money do you have in your bank account? How much property do you have? Do you have any stocks and bonds? Okay, thank you. So you fill it out, and they think, oh man, this person's like worth $3 million. So why don't I just charge them $30,000 for doing a trust? That's going to take me about 4 hours. Well, actually, it's not even going to take me. My paralegal is going to take about 4 hours to construct this boilerplate document and just put my name in there and my beneficiary's name, my executor, my durable power of attorney's name, and those types of things. I find it to be despicable. I had a client who came to me a few days ago, and they were trying to sell their house. And they thought that their house was transferred into their trust. Now, I'll talk about funding in a little while. But at the time that they tried to sell the house, the real estate agent was perplexed. It's like, Bill, I thought you said your house was in a trust. Oh, yes, it was. I paid the lawyer $5,000 to transfer my house on a quick claim deed into my trust. Well, that's funny because I did a search at the county recorder's office and it's just in your name, Bill. There's no Bill Living Trust. Wow. How could that be? So not only did it cause trouble for the real estate transaction, but Bill thought he had paid this lawyer a significant amount of money to not only create the trust by typing up the documents, which is a no-brainer, but he did not fund the trust. That's like having a car without an engine. You can have the most beautiful trust in the world sitting on your desk, but it's totally irrelevant unless you transfer property into that trust. And I'll go over that more in a moment. Okay, so what is probate? Probate, think of a will. Yeah, 100 years ago, before we had trust, or before most people used trusts, people had wills to leave their property to their loved ones. But if you remember nothing but this concept tonight, this is going to be the most important thing you can remember. Probate equals problems. Probate equals court. Probate equals delay. So if you want to guarantee all kinds of problems for your loved ones or your beneficiary, it could be a charity. I had a client who left all her money to a dog charity. No problem, it's her money, she can do whatever she wants. There's no law that says you can't have your trust as beneficiaries to any concern you wish. However, what she didn't want to do was to delay the gift. She didn't want to go through the court process. When she passed away, she wanted a seamless transfer of her property to this charity. So we created a trust. She passed away, and everything flowed beautifully to that charity. That was her intent. My mom cracks me up. She's changed her trust about 13 times. Every time she gets into a fight with my sister, oh, she's out of the trust. Oh, we made up. She's back in the trust. Yeah, back and forth and back and forth. Well, this is the beauty of a revocable trust, which means you can change it at any time you want. Right? You can change beneficiaries, you can change the property, it's very flexible. Unlike an irrevocable trust, which almost takes a court order to change. And I'll tell you about the benefits. There are benefits of an irrevocable trust, we'll talk about it, but there are certain disadvantages too, which we'll get into. All right, so again, probate is a will. Will equals probate, probate equals will equals court, problems, delays. What is a durable power of attorney? Now, as part of our typical trust package, and most lawyers will do this. A durable power of attorney lets someone take care of your financial affairs, not only if you pass away, but if you become incapacitated. Right? You're in the hospital, God forbid. And maybe you have some mental deficiency and you don't even know where your bank accounts are. Or what if it's a husband and wife situation? The husband becomes incapacitated. And because of the medical burden, the wife has to sell the family house. Oh, well, it's community property. She can just sell the house easily. Sorry. She needs to be on that durable power of attorney. She has to have the right to sell the house. Unless she wants to, forge his name illegally, which I don't recommend. But the durable power of attorney becomes very important during your life and after your life. Quit claim deed. Very important. By the way, I have printed out for you part of the slide presentation in your file. Some of the first slides. I didn't want to burden you. If you're interested in getting the entire slide presentation, simply email me. You should all have my business card. If not, let me know. Just say, hey, CJ, I was at your presentation on Thursday, the 23rd of May, and I only got part of your presentation. Can you email me the entire presentation? No problem.
You need staplers.
Stapler, yeah.
Staplers for your cards.
But if you want it, no problem. It's not proprietary. All right, back to the quit claim deed. What is a quit claim deed? This is sort of the magic sauce, if you will, in estate planning. What does it mean? Folks, there's chairs up here if you like. Like I said before, I recently had a client who tried to sell her house in a real estate transaction, but found out that the house was never transferred into the trust. The quit claim deed allows you, when you create a trust, to transfer whatever you like to your trust. So let's say you have a house in Sherman Oaks, and you want to leave that as a testament to your loved ones. You have to transfer it into the trust by using the quit claim deed. Now, how do you do this? Well, whoever does your trust or your estate plan for you should be able to do the quit claim deed, unlike that lawyer I told you about in the very beginning. So what do? Come on in, guys, there's seats in the front. So what I do for my clients is I not only prepare the documents, but I physically go down to the county recorder's office and file the papers because it has to be done correctly. There are two documents that you need. You need the quit claim deed that's properly notarized. And you need something called the preliminary change of ownership. You take the preliminary change of ownership and the quit claim deed, and I think you pay $70, and now you've got a real trust. After it's been notarized and signed, you have a legitimate legal document, but nothing is really valid until you transfer your property into the trust by quit claim deed. Now, you might say, hey, CJ, what if I have a life insurance policy that already has a designated beneficiary? Do I need a quit claim deed for that? No. And the beauty of that type of instrument is you don't even need to put that into your trust, because upon your demise, your property automatically, in terms of your life insurance, that goes directly to your beneficiary without going through the probate process. Really, most people that set up the living trust.
Can you repeat that sentence
Yes.
again?
If you have a life insurance policy or an annuity, any type of financial instrument that has a designated beneficiary. So as an example, I have an annuity. If God forbid something happens to me, my daughter gets whatever's in that annuity as it accrues. And I don't have to worry about putting that in my trust because it automatically goes to my daughter. Whatever,
Even if it's property also?
not property,
Not
this is
property,
only for
okay.
life insurance
Okay,
policy.
gotcha,
Yes,
okay.
question?
So the question is a trust necessary without real property unless you don't wanna avoid probate?
Good question. It could be. Probably not. But let's say you have an extensive jewelry collection and you want to leave that to your daughter. Let's say it's, you have some really nice jewelry, you might want to put it in trust. But if you only have a life insurance policy that already has a designated beneficiary, why bother? It would just be duplicative. It would be an unnecessary charge for you. So most of the time, if you have a house, you probably want to trust. Yes, question?
So what if you have, say, mutual funds, and you have them in trust for your spouse or your daughter? Will they just transfer directly
Yeah,
over?
I would talk to your financial advisor and find out if you have a designated beneficiary already. And if you do, then you don't have to worry about setting up a trust for that.
Okay,
Yeah, it will usually just go directly to your
Directly.
beneficiary, but you should ask.
yeah, so in theory, it becomes, just because, if something happens to me and I pass away.
God forbid, yes.
It becomes theirs.
Yes, yeah, as a pre-designated beneficiary.
Okay.
Question?
So if you're invested in other real estate?
Yes.
and you've got your family listed beneficiary, you don't have to worry about?
Oh, yes, you do. Any real estate you want to transfer.
Any real estate
Yeah,
has to be
you want that in
transferred
a trust.
into the
You really
What
do.
about bank accounts? Do you have-
Bank accounts too, unless, again, you have what we call a Trotton account, which means you have a pre-designated beneficiary. So as an example, my daughter is on my bank account. If God forbid something happened to me, she is the beneficial
Oh,
owner of
okay,
that
so
bank account.
that, as long as they're on the bank account?
Yes.
That's
Okay.
what I was.
As a designated beneficiary, not just a cosigner, that's not gonna work. They have to actually be a designated beneficiary.
Designated
On a
beneficiary.
Trotton, it's called a Trotton account.
Okay.
Yes.
Some of those bank accounts too, they have a verbiage that says POD, pay up.
Yeah,
debt.
that's fine.
Right, so that way you could avoid going through the
That's
process.
gonna be like a Trotton trust.
That's-
Question?
Is transfer upon death form another way to transfer property to somebody?
It could be, but it may not avoid probate. It probably will not avoid probate. So a trust might be a good idea.
Excuse me,
Yes.
what about if you own a business?
If
Can
you own a
make
business?
beneficiary, or do you have to add it to the?
So if you have equity in your business, I would recommend putting it into a trust. However, it depends on how it's set up. Is it an LLC? Is it an S corp? Is it a C corp?
Well,
So,
right now, it's a sole proprietorship.
Yeah, then I would recommend putting that in trust. And plus you have no asset protection, which I'm gonna be talking about later. And you have no tax benefits either, which I'll talk about in a minute. Okay, so let's see, did I cover everything? All right, so there's some other asset strategies that we're gonna talk about. One is gonna be tax bracket management. The other thing we're gonna talk about is asset protection, which I kind of brushed on. What is the difference between irrevocable, revocable trust? And I'm gonna talk about a guaranteed 20% deduction off your taxes before you even file. Okay, so let's talk about estate planning. What is an estate? That's basically all the property you own. Whether it's a house, stocks and bonds, gold, life insurance, assets, anything you own, that is your estate. What is probate? We covered it already. Probate is expensive. Probate judges are usually former probate lawyers. They're usually friends with the other probate lawyers. And they do all kinds of things like they say, you know what, this is a very complicated estate. I think you better hire an appraiser, which is gonna cost the beneficiaries thousands of dollars. The typical probate today is gonna be about 4% of your estate. So hypothetically, let's say you have an estate worth $1 million. That's a house, right? In California, that's probably a 2-bedroom, 2-bath house anywhere in the valley.
That's half a bedroom.
Yeah, half a bedroom. So $1 million estate which is minimal, think about 5% is gonna go to the lawyer for just filing some papers, right? 5% is gonna go to the lawyer for doing virtually nothing. So what would you do? What would you rather pay somebody less than $1,000 to create a trust? So there's no delay to your loved ones, there's no court costs, there's no administrative costs, and no legal fees? Kind of a no-brainer.
I'm confused, because you said unless there's real property, there's no need for a trust, even if there are assets.
No, I said probably not, but if you have like an extensive jewelry collection, let's say,
Or art, or
car,
art.
I'm glad you brought up car. Do not put your car in a trust. I'll tell you why. There are two reasons. The DMV is gonna nail you on it, okay, as a trust asset. And two, you probably won't even have that car when you're gone. You know, if you're like me, you change your cars fairly often. Now, I get a new car like every 2 or 3 years. So why would I put that in my trust and have the DMV charge me a surcharge, and then I might not even have that car when I pass away? So what's the point? Yeah, so really, if you have like gold bullion or a gold coin collection or some estate jewelry, things like that, then you might consider a trust. You might. But I would, usually the threshold that I look at is if you have like less than $30,000 worth of stuff, yeah, go through probate.
What about if you have a vintage car?
Yeah, what?
Vintage.
Vintage car? Something that you plan on keeping for a while.
Hopefully, yeah.
Probably has a value of more than $50,000.
Yeah.
You might want to put it in a trust.
Yeah.
Yeah. Yeah, not a bad thing to do.
That last thing you said, if you have $30,000, less than 30,000, did you say do or don't go through?
So I'd say if you have less than $30,000 in asset, it's probably not worth creating a trust, because what are the attorney's fees gonna be on $30,000?
Right.
5% of what?
Let us
You know?
burn it down.
It's gonna cost you about the same as creating a trust, so what's the point? The only benefit would be that you don't have that delay, the court delay, but yeah, that's kind of a rule of thumb. All right,
How
so.
long is that delay?
Every 2 or 3 years, unless you're Howard Hughes. You know, what was that, a 15-year delay before the beneficiaries got their estate? But yeah, if you're an average everyday person, 2 to 3 years. So if you have a beneficiary who has a horrible medical issue and they're counting on the assets from your trust, they're gonna be struggling. There are companies that provide funding for estates, but it's very expensive. And to me, it doesn't make any sense. It's kind of like usury, like a pawn shop. I would avoid it. All right, so what is subject to probate? Here's some things: personal property, obviously, like your jewelry, your stocks, your bonds, bank accounts, real property. I mean, this is the big one. If you have a house, you need a trust. That's my opinion. Liquid assets, again, bank account. Business inventory, business equity, retirement. What is not subject to probate, we kind of talked about that already. Jointly held property. Now let's say you own a piece of real estate as joint tenants with rights of survivorship. That means you own a 1/2 undivided interest in that property. Okay, I know somebody who owns some property with their sister as joint tenants with rights of survivorship. If God forbid something happened to one of the sisters, the other sister just gets the property. It's theirs, legally. They don't have to go through probate, they don't have to have a trust, they get the property automatically. So if you have property as joint tenants, there's no reason to put it
And the
into a
same
trust.
thing if you're just invested in a property, if you have a beneficiary as your.
No, investor doesn't have the same classification as a joint tenant.
No.
A joint tenant's a legal qualification by operational law. Says that if one of the joint tenants passes away, then the other joint tenant gets the property.
So if you invest in a property and it says Marvin and Jane as joint tenants, you know, or whatever.
If it's joint tenants with rights of survivorship,
Yeah, that's what-
then you don't have to put it into a trust.
Okay.
It will automatically pass. But joint tenants, that's different. You see, the law is very semantically driven. Joint tenants means something different than joint tenants with rights of survivorship.
I see.
If you don't have the rights of survivorship language, then you don't have that
then-
magic
then
transfer.
it's not good.
No, well, it's good,
It's good,
but
but
not
it's,
for probate.
it's good for probate.
Not good for probate.
Not good, no, I mean, not good for probate
Yeah.
if you don't have the language.
Yes, you don't have the, with rights of survivorship, absolutely. Okay, so again, we talked about a beneficiary designated property. We talked about life insurance policy that had a beneficiary, property conveyed by a valid trust. All right, what is a will? We talked about that already. A will are your wishes. You can designate an executor. So, you know, if something happens to you, your executor can take care of your beneficiaries. But again, will means a guaranteed probate. And I kind of specify that here. Will does not avoid probate after death. It is basically a guarantee that you will go to probate court with more fees and costs. A will does not protect from incapacity. And it does not protect your assets. Yes, question in the back.
I have a house and my daughter is on the deed. Does that protect us at all?
I'm sorry?
Her name is on the deed. That's pretty much it.
Her name's on the deed. She
Yeah.
owns the property.
So her and I are both. So do we need
You're
to?
both on the deed. When you pass, then she owns it.
So you don't have to do a
No.
trust for the house? Okay.
No.
'Cause that's all I did. My husband passed away. I just put her name on the deed.
Yes. And you're gonna have to look at the deed the way it's, the language works. But if there's some language that says, you know, each person owns 50%, and if it's owned as joint tenants with rights of survivorship, then she gets it.
I don't know. I'd have to check it out.
Yeah.
I just went
We
to
can
the
take a look
county
at it
with the
tonight.
name on it, yeah.
I'd have to take a look at it. All right. So again, the other thing, I wanted to kind of dispel a rumor real quickly. A living trust or a revocable trust does not protect your assets. So if somebody sues you while you're alive for anything, and you think you have asset protection from a revocable trust, think again. A creditor could simply reach into that trust and grab whatever assets there, because you technically still own it. One question that comes up fairly frequently is like, okay, CJ, I want to put my primary residence into a revocable trust, but I don't want my children to kick me out of the house if we get into an argument. No problem, you still own the property. And here's the illustration. The antithetical concept of a revocable trust is an irrevocable trust. And there, you do have to be afraid. I had a client who wanted to create an irrevocable trust. Their CPA advised them to do that. And actually, CPAs aren't supposed to give that kind of advice, but they did. He said, you will avoid some taxation if you create an irrevocable trust and put your house into the irrevocable trust. So what happened? Well, the mother and father created this irrevocable trust in favor of the son and the daughter. Somehow the son and the daughter got into some kind of an argument with the parents, and Bob Jr. said, hey, mom and dad, guess what? We're evicting you. You want to get out peacefully, or should we call the sheriff and file the eviction proceedings? What are you talking about? Well, you created an irrevocable trust. We own the property. That's absolutely true. They legally own the property. They own that house. Once an irrevocable trust is created, the beneficiaries own that property. They can lease it, they can rent it, they can evict the people that live in there. Now, there was some scare about a year ago about the stepped up basis, you may have heard this, for property taxes. It used to be in a revocable trust, you could pass your property to your beneficiaries and they are not going to be prejudiced by the increased value of the house. They take the value of the house at the time it was purchased, the fair market value, as opposed to the time it is sold. That changed. The law said now only if you have an irrevocable trust can your beneficiaries take advantage of that stepped up basis. So I was getting phone calls right and left. CJ, I want to transfer my revocable trust into an irrevocable trust. Okay, do you realize that your beneficiaries can kick you out of your house? Do you realize that it's almost impossible to change your irrevocable trust without a court order? Do you really still want to do that? Yes, my other lawyer said I should do it, and that's what I'm motivated to do. It's like, you know what? I don't really feel good about doing that. As a matter of fact, I will not do that. So please go somewhere else. Because I think the headaches and the problems far outweigh the potential of saving money on property tax. That's my opinion. I'm sorry. I'm sure you can find somebody that will do it for you. But at this point in time, I don't even know if it makes any difference anymore. I don't know if even creating an irrevocable trust will help you give that stepped up basis to your beneficiaries anymore. I'd have to research it. It's something that I don't play around with, so I don't know. But my personal opinion, I wouldn't do it. It's too dangerous. Okay, we talked about a trust. Basically, a trust is simply a contract between you and your loved ones. That's all it is. It's just a formal contract. You can have a 15-page trust, and it works beautifully. Or, like I said, you can go. There's some seats in the front here. There's one chair here too.
Oh.
Seats in the front,
There are seats in the front.
What is
So-
this meeting about, or
prime real estate.
prime estate? Oh, okay. Location.
There you go. Always.
I didn't mean it that way, but.
No, fair enough. So again, you can go to a lawyer in Century City or Beverly Hills or Encino, and you can pay $4,000 for a beautiful trust. Do 2,500 pages in a beautiful binder with your name on it, embossed in bronze or platinum, however you want it. But in essence, a 15-page trust will work the same. If you fund the trust, this beautiful trust is worthless if you don't transfer your property into the trust. I've said it a million times. By now you get the point. All right, so this again is just kind of a reiteration of the difference between revocable trust and irrevocable trust. Yes?
Are trusts state specific? Do
Yes.
different states have
Yes.
different?
Yes, absolutely. So, as a matter of fact, I got a call from somebody the other day, and he's from Illinois. And they created a trust in Illinois. They said, hey, is that still good here? Probably not. We do have different tax laws, we have different exemptions. It should be done according to the state that you either live in or where the property is. Question?
Yeah, if I have out-of-state property, then I have to have a separate trust in that state.
Not necessarily.
Okay.
You can transfer it, you can create the trust here and transfer it into that. I had a lady who lived in Iowa. We created the trust here and we transferred her Iowa property into the trust. No problem. Question?
I'll say.
Her house is probably gone now, she's in Iowa.
Pardon me?
Her house is probably gone now, she's in
Oh, you're
Iowa.
right, yeah, I hope not. That's a good point.
Hope not, awful.
Okay, so an example of a revocable trust, we already talked about that. You want to have an executor. You want to have, again, designated, we talked about the power of attorney for your financial affairs, durable power of attorney. What's the difference between a durable power of attorney and a regular power of attorney? A durable power of attorney lasts indefinitely. You can have a temporary power of attorney. Let's say you're going on a trip and you want your daughter to take care of paying your bills, right? You can do a temporary power of attorney, but for a trust, we're talking about a durable power of attorney that will last during your lifetime and after your lifetime. You also want your beneficiaries stated and your alternate beneficiaries. Now, what does that mean? Let's say you have a daughter and she's 60 years old and maybe she's in poor health. What if something happens to her? You don't want your property to escheat. Write this down. The word is E-S-C-H-E-A-T. If you don't have a will or a trust, your property goes to the government, which means you're definitely being cheated. So the Latin term is escheat, E-S-C-H-E-A-T. If you don't have a will or a trust, then your property is going to be cheated out of your beneficiaries. So
Just spell that again.
E-S, E like Edward, S like Sam, C like Charlie, H like Henry, E Apple, E Edward, A Apple, T Thomas. S cheat. Yeah, so if you don't have a will or trust, your property and your beneficiaries are no longer here. That property could go to the government, state of California. So always have an alternate beneficiary. Again, it could be a charity. Some people leave the money to their pet, and they tell their trustee, please take care of my pet if I go. Your trustee is the person, you are the original trustee. Or if you're married, your spouse, you are the trustees. However, if God forbid, if something happens to one spouse, the other spouse is now the trustee. If God forbid something happens to both spouses, then you need a trustee. We call it an alternate trustee. I recommend finding somebody that you really trust. You probably don't want to be one of your beneficiaries. You can, but if you have two beneficiaries and you make one the trustee, there could be a conflict of interest between the two individuals. So, find a great family member that you trust or a great friend. Some people, they have a hard time trusting a family member or friend, so they go to the trust department of Bank of America or Wells Fargo or Citibank, and for a fee, they will administer your trust. I think it's 2%. I don't know exactly, but that's also an option. If you want to name the alternate trustee as a bank, you can do that. No problem at all. All right, special needs trust. Again, this doesn't come up very often, but if you have a beneficiary, primarily a child that has a disability that prevents them from working, probably, you want to create something called a special needs trust. This is a very special. Not too many people create them, but they are available. They're not cheap, but they are available. Durable power of attorney, we talked about that. Again, that gives your agent the right to sell your property, to make decisions about your finances. And remember, you can tailor that power of attorney however you wish. You can say that my agent under the durable power of attorney can only lease my house. They cannot invest my money in other property. They cannot change my beneficiaries. You can be very specific what you want your durable power of attorney to do and not do. Now here's one other thing. In California, we have the California Healthcare Directive. Don't confuse this with a trust. This is a document you can get online for free. And this tells a hospital what happens if you're on life support, God forbid. Now, do you want to remain on life support? Do you not want to?
Just about people, I think.
Yeah, it depends. But there are lawyers that charge people to create this California Healthcare Directive, which I find obscene. You can do it for free. You just go online, type in California Healthcare Directive. It's right there. It takes 10 minutes to fill it out. And you can take it to your hospital or your doctor so they know in advance what you want done if, God forbid, you become incapacitated.
But you give your power of attorney to somebody, can they sell your property? Can they just?
If you allow them to.
So if you say specifically, he cannot sell it.
You also say specifically they cannot sell it. You can tailor it however you
Or
wish.
borrow money on it.
Anything. It's very
Or you
flexible.
can put in it, like this power of attorney expires on such and
You
such.
can. Then it's no longer a durable power of attorney. It's called a fixed power of attorney. Like I gave the example of, I'll get to your question one second. You're going on vacation and you want your neighbor to take care of your dog, and she can invade your bank account if the dog gets sick. But when I come back from vacation, that power of attorney is extinguished. Most of the time when you're doing a revocable trust, You want a durable power of attorney that lasts indefinitely. And you can tailor it however you want it. I've seen some durable power of attorney where they only gave the right to lease their property, not to sell it. So it can be as creative as you want. Question in the back.
If you have a revocable, living trust that just has the family home in it, what do you put in the will?
Okay, good question, great question. All right, so let's talk about that. There is something called a pour-over will. What does that mean? Let's say, this actually happened to one of my clients. Let's say you just bought a piece of property, rental property, and right after you closed escrow, you got into a car accident, a fatal car accident, and you did not have time to transfer that property into your trust. You're no longer here, and you have no surviving spouse. Does that property now go through probate? Does it defeat everything that you wanted to do in the first place? If you have a pour-over will, any judge in this state, probably any judge in the country, will look at your intent. That means you probably had the intent to transfer that property into your trust, but you weren't physically able to because you're no longer here. So effectively, if you create a pour-over will, you're not going through probate. That becomes part of your trust. Sort of a saving gap measure, if you will. Does that make sense?
So if the family home is in the revocable trust, does it make sense to put art, antiques, and furniture and jewelry in the will?
No.
That
Put
should
it
all
in
go
your
the
trust. We have an exhibit A, back to the trust, where you can get specific gifts to people. So my Aunt Mary's wedding ring, my grandma Frances's whole silver set. On exhibit A, you give property to your intended beneficiaries as a specific gift. Do not put it in the will, because that's going to go through probate. Now,
All wills go through probate. Every will goes through probate.
unless it's a pour-over will.
Unless it's a
If it's a pour-over will that's created in conjunction with your living trust, you're good to go. Question?
You said if under 30,000, that a trust isn't necessary. If there are
That's
assets
just
of
my
a couple of
opinion.
100,000, there should be a trust even if it doesn't include real property.
I think so. That's my opinion. There's no law. That's just my opinion.
So I have a question for you. So your pour-over wills
Yes,
should be created simultaneously with your trust?
absolutely.
Okay, and so when your pour-over will is completed simultaneously with your trust, it doesn't matter that you convey said property to it because by virtue of creating it, the intent is implied.
Now,
Is that correct?
in specific situations, right? I mean, the situation I gave you was pretty extreme. This is sorry about that. A person who passed away before they had a chance to transfer their property into the trust.
Right.
But, person's still alive, and they just didn't transfer it
Right.
because either the lawyer was lazy or they didn't tell the lawyer to transfer it. That's not gonna really help them. The pour-over will is only gonna create a remedy if there was some life situation that prevented them from transferring the property by way of a quick claim deed into the trust.
Have enough.
Yeah.
So I have two other questions. So why are we transferring it using a quick claim as opposed to a grant deed? Because grant deed conveys more as opposed to quick.
So a quick claim deed is used in a trust situation. So when you fill out your preliminary change of ownership, you're not gonna pay any property tax.
Right.
There's a very specific format that you need to follow. There's a box that you check that says, I'm transferring property from myself or my husband and my wife into the trust. therefore there's no tax consequences. And that is what you need to do for avoiding probate. The quit claim deed. A grantee, when you first buy the property, you can say, I'm buying, ABC property as husband and wife, or as joint tenants with rights of survivorship. But to avoid probate, you need that quit claim deed and a preliminary change of ownership.
So then the last question would be, is there a duration of time, as you intimated that one would have to pass today?
There's no law.
Okay, so that means that I can get the 4 will with my trust.
You should.
And then not me, but somebody else passed 20 years from now. But as long as the intent is conveyed, because things happen in life, you don't get a chance to get.
Well, again,
20 years.
a judge would look at the duration between the
Okay.
demise and when they, should have transferred it. There's no law.
So it's common sense.
Yeah, I
It's
mean-
common sense, okay.
I would say, if I'm a judge and the person waited 3 years, why?
Okay.
But if they had a heart attack and they died and they didn't have time to transfer, then the 4 will's gonna work.
Got it, okay.
You have a question, I'll go with you.
The first thing is you're basically talking about your house and your assets, your bank account, things like that, all over the trust.
Yes.
If you don't have that many people that you would be passing things to, like, I got a kid, with no argument about anything, I don't have all the things I have in my house, that doesn't have to go into a will or anything.
That's up to you.
But
I
the only
would,
part is the argument about among anyone else who might say those assets could be theirs as well, right?
that's really not the objective of a trust,
Not the trust,
to
the
avoid
will.
Again, will is probate.
But
So you wouldn't put anything on will, so why are we talking about?
Only a pour-over will,
A pour-over.
in conjunction with the trust, but just to have a will and no trust,
No, I'm not talking about that. So if you have a trust, you
Yes.
put the stuff in the trust, you put your house in the trust, you put the bank accounts
Yes.
in the trust.
okay?
And then the little thing, my phone, whatever, that's not gonna go into probate,
No.
right? Okay, my second question is, are you going to talk about divorce at some point?
Not specifically, but I want to answer the question. I'm not a family law attorney, so it's not my area of expertise. It's like a cardiologist treating somebody for skin disease. Yes.
Sorry, it might be real clear to others, but for me, so understanding everything should be put into a trust, but you're also explaining that we should also do a pour over will.
Yes, absolutely.
Right, versus just a regular will. If you
Yeah.
only have a will, everything goes into the program, but if you have a trust that lets.
Or will trust, yeah. I don't know of any law firm that would create a pour over will along with a pour over trust. What do you think is it?
Got it.
You have a question, ma'am? You have a question?
Yes. So, but if you have a beneficiary in your bank account,
No. Again, those are pre-designated beneficiaries, they don't need to go into your trust. They will avoid probate by operation of law.
What was it, her question? We couldn't hear.
Oh, she was asking,
No, at the end.
at the end. The question was,
It was just this simple, you're supporting your trust with a pour over.
Oh, yeah.
That was it.
Uh,
Yeah, I just need.
Four will should be with trust. Then somebody else asked if they had a 401k and a bank account that already had a designated beneficiary, do they need to put that in a trust? The answer is no.
Yeah, so in her case, since she has just a son, or who had one kid, she could leave her bank accounts in trust for,
It's in a trust.
Yeah,
with a
absolutely.
trustee, and then
that it doesn't even have to be in a trust, it could just be on the account when
Yes.
she opens it. You don't even need.
If you just had a bank account and no house, you could use a Trotton account and put them as a pre-designated beneficiary. House, you can't do that. Question?
I don't know if you already answered this, but, the standard will, can that be converted to a pour-over will? Or is that a separate document?
So completely different documents.
Okay, that's a document, sorry.
Yeah. Or will have to be created along with the living trust.
So if a change happens, so they have to be changed to both. If you include anything new into a trust, it has to be reflected into the.
Okay, that's a great question. What if something changes? I'll get your question. Let's say that you have two beneficiaries and you fall out of favor with another beneficiary. You can amend the trust by doing an amendment. You don't have to do a whole new trust. You do like a 1 or 2 page document called amendment of trust. But you cannot convert a will into a pour over will. You have to create a new document in conjunction with the living trust. Because it's only, the pour over will only supports the living trust. They work together.
So So if you make an amendment to the trust, you have to make a new forward will.
Not necessarily,
It's an
unless you're
amendment.
changing something in the will too. I mean, if you're changing beneficiaries in the trust, then it should also be consistent with the will. But some people say, hey, I sold a piece of property, does that mean I need a new trust? No. You don't need a new trust if you sell a piece of property. So you got a question?
Get back to the bank account, you need a designated beneficiary.
Yes, pre-designated
And
beneficiary.
not just the signer.
No, signer doesn't matter.
So once you
Co-signer is
pass
relevant.
away, the other person doesn't automatically
No.
get the use of that money.
No, you gotta talk to your banker.
That's very interesting.
Yeah,
because
you
I
talk to
didn't
your
know that.
banker, say, I wanna put this person as my
Yeah, they
pre-des-
never, you think they would mention that
Why
when
would
they open
they?
the account?
Doesn't give them any money. Banks only care about making money, they're not gonna do anything to help you.
Yeah, really.
I mean, that's my cynical opinion.
But if you're naming it when you open an account, if you're saying, Joe Smith's my beneficiary, then they
It
get
has
money.
to be written, it can't be oral. It has to be on the account as a pre-designated beneficiary. There's a form that you
It has to be a signed form.
That's correct.
So, open up the trust and a quick claim deed at the same time, but the quick claim deed is just for transferring real property.
Okay, great question.
Real property, right?
Let me go over just some of the
Okay.
technicalities here, and then, boy, we're running out of time. But, when you create the trust, it needs to be notarized. And the quit claim deed needs to be notarized. The durable power of attorney needs to be notarized. The preliminary change of ownership does not need to be notarized. The pour over will needs to be witnessed, not notarized. Along with the quit claim deed, to transfer your property, you need a fully notarized trust and a notarized quit claim deed and the preliminary change of ownership. You'll need all of those things, which the lawyer should do for you.
Yeah.
Now, in some cases, you know, like I had a client who was very savvy, and I created the trust and the quit claim deed and the preliminary change of ownership. She walked down to, I think, the Norwalk County Recorder's Office and handled the papers herself.
Say that again, please.
I had a client who was very savvy. And I created a quit claim deed and the preliminary change of ownership. She physically walked into the county recorder's office and recorded the instrument herself.
Yeah.
Question about.
Can you repeat, like, list what you need notarized and what you don't?
Yes,
need
what
notarized?
needs to be notarized and what doesn't. The trust needs to be notarized. The quit claim deed needs to be notarized. Durable power of attorney needs to be notarized. Pour over will does not need to be notarized. The preliminary change of ownership does not need to be notarized. Eat my food, people, I don't wanna take it home. Yeah, we'll grab the water, though. All right. Let me move ahead a little bit here.
I got a question.
Yes.
Do you have time? Okay, what if you donate to charities and you want those charities in your trust? I mean,
Donate to them, or if you wanna leave them as a beneficiary?
if you wanna leave them, I mean, yeah.
If you wanna designate them as a beneficiary, they need to be listed as a beneficiary.
And then, can you do a percentage or?
Yes, yes,
Or
all
it
the
has to
time.
be a set amount?
All the time.
And if you,
It's very flexible.
yeah, okay.
The standard is like, you know, if you have.
But you have to have it figured out before you do your.
Yeah, yeah. I mean, you can
Yeah.
change it later, but standard template, I guess. If somebody has 3 kids, they just leave everything equally to the 3
Right,
kids.
right.
Now, other people do it differently, you know? So it's just however you wanna do it. You can leave 20% to the charity. You can leave 80% to your kids. You can leave 5% to a political party. It doesn't matter.
I just made me think, so if your pets, cats, dogs outlive you.
If your pet outlives you?
Yeah, you're gone and you've got 3 cats. Can you have it set up so the cats can go to a sanctuary and you're gonna donate?
Yes.
You know, $4,000.
Absolutely.
That's in the trust.
Yes. You can designate that way. Absolutely.
What is that, is that a written thing?
Yeah, it's just part of your trust, like if something happens to,
My cats.
Salvi, my cat, then I want the money to go to ABC Pet Sanctuary, whatever.
And you can specify the
Absolutely.
amount per cat.
Absolutely, percentage of, or a dollar amount.
Yeah,
You
dollars.
say I want $5,000 to go there, yeah,
Each cat, yeah.
absolutely. You can be as creative and as flexible as you want, no problem.
That's called like an instructions trust.
It would be a beneficiary designation.
So she's still gotta have somebody know that's gonna guarantee the cows get to the
I have a question.
Yeah, that would be
That'd be the.
something you wanna talk to your trustee about,
Uh-huh.
ask him if they're willing to do
If
that.
you have a son and he died,
You have a
but he
son,
got the
is that-
money already, and then the wife will take over after that?
Not necessarily, no.
Or the kids?
It's how you designate them, how you specify it. in
Also,
the
you
trust.
have to specifically say.
Absolutely.
So you have to say, it's for the son, wife after divorce, or
Okay,
whatever,
yeah.
cannot, that is,
So a gift, okay? Somebody asked about family law. All right, so, you know, of course, I studied family law in law school, but I don't practice family law. In California, as you know, we have something called community property. All right, now, if I bought a house after I'm married, and I use my wages and my wife's wages to buy that house, that's community property. If I put a deck on the back of my house, I used my wages during marriage to create that deck, that's community property. If my mother gave me $300,000 to buy a house, that's a gift. There is no community property there.
Even if you're joint tenants on the deed, there is.
Well, you could possibly overcome the presumption of a gift if you title the property differently, but assuming it's just like, hey, this is my property, it was a gift, then it's my property. Now, if I put a deck on that property using community funds, wages that I earned during marriage, now I have commuted that separate property gift to a community property asset. It's called commutation. Yeah, I'm not gonna get into details right now, but typically in an estate, you can designate whoever you want to be the beneficiary. It's not the wife of your deceased son by virtue of community property, unless you want to present it that way, because it's a gift. It's not wages.
So-
Isn't there a gift tax if you give that kind of a gift to whoever? You have to pay taxes on it?
Okay, so typically most gifts are not taxable from the recipient's perspective. And every year you can give up to $13,000 to anybody you want to and avoid gift tax.
But that's it?
Yes.
If you go more than that, you have to pay tax.
The beneficiary won't have to pay tax, but you will be subject to gift tax if you do more than $13,000 per year. Okay, let's move on.
You know, the
Yeah,
rough,
if
the
you-
rough tax, what's the rough tax rate on the person giving them the?
Yeah, person giving
Yeah.
is one who's subject to gift tax. Person receiving gift, it's a gift.
Right, do you know the, like, rough percentage of the giver?
No, I'm not that familiar with the gift tax. I can find out if you wanna make an appointment, I'd be glad to.
30,000 is for once a year, or you can have a lifetime?
Do what?
Once a year.
Can you do what, I'm sorry? Can you do what?
13,000 gift.
Yeah, once a year,
Once a
yearly,
year.
yeah. You can give $13,000
Once a year.
every year to anybody you want.
So if you have more kids, you
You
can
can
have.
give it to
half
100 people,
and
you give it to
half.
your postman, you can give it to your doctor, doesn't matter. All right, now, one more thing I really want to leave you with before we start opening this up to more questions, is the concept, and whether you like Donald Trump or not, I'm not here to talk about politics. I'm not a political person. But, as my good client, Dr. Vidal knows, by forming a business entity, you now can take advantage of what we call the 2017 Tax Cut and Jobs Act. What does that mean? If you have a business entity, other than a sole proprietorship, if you have an LLC, a C Corp, or an S Corp, you automatically get a 20% deduction off your federal income tax before you even calculate your standardized deductions or your itemized deductions. Example, your business earned $100,000 last year. That's your taxable income. Your tax liability is going to be based on that $100,000, right? Now, you create an entity pursuant to the 2017 Job Act and Tax Cuts. Now, your taxable income starts at $80,000. Then, you get whatever your standardized deductions are, or itemized. Maybe your standardized deductions are better than your itemized. Or maybe you have a home office, and your home is 80,000 square feet, and your office is 10,000 square feet, and the fair market value of that is, $8,000 a month. That becomes an itemizable deduction. So what am I telling you? Create a business entity. Well, I'm a W-2 employee. I'm a doctor. I work for Kaiser. Okay, that's fine. Open up a consulting company. Create an LLC. Go to the Secretary of State website, or I'll do it for you. Come up with a name that's not your name. Right? If your name is Jill Smith, come up with the Golden Eagle Florist LLC, whatever. By virtue of creating that entity and showing some profit within 3 years, now you can take advantage of this 2017 Act. Now, cautionary comment. Again, I'm not political, but the rumor is that if the Democrats get reelected to President Biden, I guess, or somebody else, on their agenda is to get rid of this tax benefit. However, my understanding is that if you create it, you create your business entity now, you will be grandfathered in going forward. So I'm kind of scaring people when I talk to them. If you want to take advantage of this law, do it pretty quickly, at least before November. And it doesn't matter, like, oh, well, I don't really, I work for wages, I don't have a business. Create a side business and funnel all your money into that LLC or S Corp or C Corp. But
So the money that you make from your day job, your actual wages, you put that into the LLC?
everything,
Everything. That's so, like, but then when you're doing your, when you're then doing your, accounting for the LLC, what do you call that?
well, you have
Because it's
separate,
not-
yeah, there
because
is a
it's-
corporate filing or an LLC filing
Right,
alongside of your personal income tax.
okay, so you just call that like investment in your
No,
business?
call it whatever your LLC is. This is my LLC return.
So if somebody's working for wages, they still start this
Absolutely.
LLC.
I just
They
had
put
a,
their checks in the.
yeah, you deposit, now, here's
My
one
kids-
caution,
yeah.
one caution, okay? Not everything's perfect. An LLC, an S Corp, and a C Corp, they also provide asset protection. A sole proprietorship doesn't create any asset protection. A living trust doesn't create any asset protection. If you're, let's say, a doctor, a plastic surgeon, and you goof up on somebody's, I don't know, nose job, and the patient sues you for $1 million, and your insurance is only $500,000. Now, this patient, if they sue you and get a judgment, they can put a lien on your house, right? If you don't have a good umbrella policy. But if you have an LLC, an S Corp, or a C Corp, that protects your personal assets. Bank accounts, real estate, everything. I'll get to it in a second. Let me just finish this up. The downside of creating an LLC, an S Corp, or a C Corp, you have to pay to set it up, it's not that much, but every year you have to pay $800 to maintain it. But think of the tax savings that you'll get, far outweighs that $800 a year. It's not for everybody, but it's something to think about. I saw your hand up.
Yeah, so, cause I like to, you know, have the S corp, so I can, you know, I have the S corp directly versus, and then technically I can. But you said something that was really interesting about how should be in there, so how does one?
No, I didn't say how
Okay.
should be in there. I said it will protect
So how
you.
does the S corp protect my house?
Because any type of entity, whether it's an LLC,
Yep.
an S Corp, or a C Corp,
Yep.
if they sue you,
Yep.
they cannot get your personal assets by operation of law.
Oh, the house, the car, the anything?
Nothing.
So it offers you that corporate veil protection, right?
Yes, and I'm glad you mentioned that. There is a way of what we call piercing the corporate veil. What does that mean? So, let's say that you have a corporate bank account, like an LLC bank account, C Corp bank account, S Corp bank account, and you put all your wages in there, or your consulting money, whatever. And your grandmother or your brother gives you a gift of $10,000, $10,000 check. You put that $10,000 check into your LLC account, you have destroyed the LLC. You have now allowed somebody to pierce the corporate veil. They can reach in if they suit you, and they trace those assets. Hey, where does $10,000 come from? Oh, my brother gave it to me. Why did you do that? You just destroyed your protection. Now you have no asset protection whatsoever. Question?
I know we went over this before, but you said S Corp, C Corp, LLC, they all get the 20.
Any of them. Any business entity.
What happens when you do deposit that check from, and then it pierces?
Okay.
Will I start over, or? I mean,
Great question. What happens if you deposit the gift check from your brother into your entity account? It only matters if somebody sues you and they try to attack your personal assets. If nobody's gonna sue you, it doesn't matter. It's a precautionary idea. It's something to avoid if you can. Put that $10,000 into your personal account. Yeah, just avoid the opportunity for somebody destroying your corporation or your LLC. But it doesn't automatically just, evaporate unless somebody sues you and they take your deposition. Hey, where'd this $10,000 check come from? Oh, it's from my brother. It was a gift. Oh, really? Now we're gonna take your house. Thank you very much. Question here and over here.
You can give the money as an investment, you put in your money in the investment so that you can take care of the expenses.
Absolutely.
But then that's not piercing the
No,
corporate veil.
it's only piercing if you combine a gift with your income or your business money.
But your own income, you can put it in there as a
All day long.
reinvestment.
Put it under consulting income.
And then that's still protected.
Yes.
Under this.
Yes.
So just make sure you put it in the right thing.
Yes.
Okay.
Question?
Yeah, you mentioned that your home is protected if you have your LLC, blah, blah, blah.
Yes.
How did you have property that is owned by corporations?
What is protected by the corporation? That's even better. Yeah. Yeah, that's a protection. Okay. I'm gonna leave it open for like 10 more minutes for some questions and answers. Then, there is a board in the back of the room. If you would like a follow-up appointment for a strategy session with me, it's also no charge. What I will do, based on your particular situation, whether you're interested in tax planning or estate planning, I will create a report for you telling you what you might consider doing as part of your estate plan or your tax plan. Again, there's no charge for that. There's no obligation. You can leave tonight and say, hey, thank you, CJ, I learned a little bit, and I never want to see you again. That's fine. No offense taken. Or, if you'd like to have us run a report for you, you can talk to Behar here, and she will give you an appointment. What you'll do is you'll take a little Post-it tab off that board. You'll give us your name and phone number and email address and what time you would like to come in for your appointment. Now, on this little board, funky little board in the back. If you do not find a time that works for you, don't sweat it. We'll work something out, all right? This is just kind of an organized way of giving you pre-designated appointments when I know I'm going to be available. But, say, hey, I can only make it on Mondays at 9 o'clock. Okay, no problem. Just tell Bahari, and she's gonna put your information in this little book, and we'll call you or email you and remind you of your appointment. Yes, a couple more questions and then we're gonna wrap it up. Yeah, I saw your hand first.
If you have a revocable trust with family home in it, and you're leaving it to your two children.
Yes.
When they go to sell the house, do they get to use the same tax base, which is the original purchase price?
No, I went over that. They just changed the law last year. Only if you have an irrevocable trust do they inherit the tax basis of when you purchase the property. There were people that were panicking right and left, calling me up and say, hey, I want to turn my revocable trust into an irrevocable trust.